After Andrea Johnson came to the Commission to tell lies about IDAC, Seseko has spoilt her name and reputation after he mistakenly told the Commission the truth. Initially, he tried to lie and conceal the truth from the people, but when Advocate Madlanga started his subtle grilling, same Seseko who wanted to lie saw himself spilling the beans. He made several shocking admissions and exposed the truth about how Andrea Johnson and the entire IDAC have been working hand in hand with top politicians and other criminals in this country. He exposed the actual perpetrators behind the arrest of General Kumalo and those who tried to implicate Masemola and Mkhwanazi at all cost. At some point, he agreed and said he and all other members of IDAC are all criminals. It was a brutal battle, and everyone deserves to watch this interesting testimony. Grab your popcorn, take a seat, and watch with me till the end. Do you believe the entire IDAC members should be dismissed and arrested? If yes, hit the like button, comment arrest them all, and don't forget to subscribe for more updates. Dlamini, roll out those interesting clips for my lovely audience to watch.
I'm trying to determine whether it's this a person problem that you ended up in this position where you don't know about investigations that are happening because they're being directed by the ID and who chooses Mr. Perumal, Mr. Pareachi and others. Is it a problem that a different head of investigation would have been correct to say, I'm head of investigations and I will not be excluded from investigations, or it's a misunderstanding of your role by both you and the ID, that you are also subject to that rule of practice, that you don't need to know what's happening in matters. I think put simply, is this a structural problem? Is it we happen to have the wrong people in the positions. We have the wrong ID in the form of Ms. Johnson, who did things the way that she did and excluded you, or we had or we had a wrong head of investigations who didn't assert his role and position when he gets excluded. Can you just say which one it is? And the question is important because, at least from where I'm sitting, because among the things that the Commission is required to do is to make recommendations, including recommendations about what improvements, changes need to be done to the organization. So we are going to have to grapple with how did IDAC land where it is today. Is it a structural problem? Is it that whoever employed Ms. Johnson just made a bad decision? Whoever employed Mr. Seseko made a bad decision? You understand what I'm saying? What I'm asking you. Can you just comment to that?
Chair, the fact of the matter is, in this particular instance, rules were not followed. And I took a decision at that point in time, as I explained in my affidavit, based on my personal history. I take full responsibility that I should have acted differently. But at the time, for me, it was the right decision to take, given the considerations that I've said to the Commission.
I understand, and thank you for that answer. It's trying to understand what's behind my question, whether in terms of your contract of employment, which sets out what your job is, you could have asserted to the ID, even if she didn't like it. You could have said, there is no investigation that will happen that I don't know anything about. Does your contract, the terms of your contract, give you that kind of standing, or it's a problem in the contract because maybe she still gets to make decisions finally about investigations. I'm trying to understand that. So I'm trying not to make it personal to you, but to understand what are the limitations other than your personal circumstances. Another head of investigations, will they not find themselves in exactly the same position for different reasons?
Perhaps to add to that, besides the contract of employment itself, or in addition to that contract, there are the annual performance, what do you call them, which you sign with your boss, undertaking that you are going to perform in accordance with, and then, as I understand it, there's itemization of all of everything that you undertake, you are going to do during that year. Am I correct that there is such a thing? What is it called?
That is correct. The performance agreement.
Yes. Now, I'm adding to what Commissioner Baloyi says, which is a reference to the employment contract itself, and I'm saying there's also this performance agreement. Would what you are required to do not also be, it would obviously be included in that, and would it cover what Commissioner Baloyi is raising, and if it would, what would you be assessed on if not on that? That is what it covers, which includes the issues that Commissioner Baloyi is raising. At the end of the year, how do you get assessed if you've not said, now if you do not allow me to do A, B, C, D, how am I going to be assessed at the end of the year? So basically that contract would require of you to raise the issues that Commissioner Baloyi is referring to. Now, can you please respond, with all of that in mind, can you please respond to Commissioner Baloyi's question?
Thanks, Chair. My performance agreement provides that I must advise the ID. As I've indicated that these matters were discussed and should take a particular position. I understand the concerns, and in hindsight, maybe I should have taken this issue even further and not let it be as I did. But that's what, to me, at that point in time, seemed right to do. As I said, that maybe I should have acted differently by raising this issue at a higher level, so that what now has been ventilated here could have been stopped. I do, however, I'm, however, not sure if it would have made any difference.
Sorry, you may carry on.
No, I was saying that I'm not sure, however, if it would have made any difference.
You say you're not sure because the ID is the person that she was, or what? Because you see, you speak of, you say your contract says you advise the ID. The next question is, well, what does that mean in fact? You advise her on investigations that your people are doing and what they put together, is it before she makes a decision? Does advising mean that you say to her, on this investigation, there's no case? She ultimately, gets to sign off on the next steps. But what does advising her entail?
Advising the ID, it means advising her on all operational issues. where matters are under investigation, what are the challenges, what needs to be done. Most of the time, what happens in practice is that decisions like enrollment and so forth would happen when there has been a meeting of all stakeholders to discuss that matter, and when there is a consensus that the matter must be enrolled. But my advisory role is where there are issues of that affect the projects, so that we can discuss how we overcome those issues. In relation, for instance, to these specific issues that are raised here at the Commission, there would have been discussions about it to say there are issues that have been raised. There is concerns about these things, and she would give that direction to say, no, I'm satisfied about these things. This matter will go on. If there has to be a takedown, the takedown must go on.
You see, from the evidence, say, let's take the Mukwele matter, that it has appearances. Even we haven't made any final decisions, but concessions made by the witnesses. There seems from those concessions to be an acceptance that there were shortcomings in the investigations. As at least one area, there were shortcomings in the investigations. The question that it prompts for me is, where was the head of investigations when there were these bad shortcomings, these serious shortcomings, and the matter gets J50 issued, people get arrested and they go to court? Where was the head of investigations when this happened, where a poorly investigated case lends at people getting arrested and people getting to court? Even before that, it lends at a decision to prosecute. Now, from your answer, it's still not clear to me that things got that bad because the head of investigation was missing in action for reasons that you give. Or look at the perimeters of my powers, my position. I can't do more than forget that I didn't tell the ID maybe. But if you look at my contract, I can't do more than just saying, ID, this investigation is poor, the matter is not ready to go to court. In the end, she makes the decision, because if that is the case, it may well be that recommendations or thought must be given to how do you give the head of investigations more power, or ensure that in their contract they get to make determinations about investigations, and they're the ones that sign off to the ID to say, yes, I'm happy with the investigation. And until there is that sign off, the ID may not approve, may not give a decision, or may not sign off. I'm trying to get you, to assist us in answering that kind of question. And I must say that in your answer, the way you've answered, I haven't gotten the kind of assistance that I'm looking for, or the answer to my question.
I understand, Commissioner. The reality of the matter is that this investigation was directed from the ID's office, not from my office. All decisions relating to it were directed from that office, including the takedown. I learned of it after the fact, when in normal circumstances, in a meeting, discuss how that takedown would look like, whether there's a warrant of arrest to to be applied for, or HA 175, all those issues. That was not the case in this specific matter. So it was an unusual situation, and I think that's the best way I can answer your Commissioner.
Would you consider as an appropriate suggestion that I put to you that the system, the structure has to be such that the ID should not be immersed in the investigations, should not be directing investigations, because ultimately her people must satisfy her when she make him her. When they make the decision now, as they're empowered to do, starting with the 2813, right? 2813. The ID should be sitting as a neutral party, so to speak, where others come and persuade her, we need a 2013, and then she can interrogate what they're doing at that point. And then they go and do their work. Now she must authorize an investigation. She should not have been involved in the process of directing, go find this, go find that, because ultimately when they come to her for the, to her in this case, because it was a her, for a 28-1, she must look at it with a fresh eye, with an unbiased eye, if you like. The same for all the various stages that she must authorize. Would you consider it an appropriate suggestion that the ID should in fact be insulated from all of that, so that by the time she's required to exercise the statutory powers of being the ultimate decision maker on the different steps, she looks at things with a new eye and an unaffected eye?
Commissioner, I agree totally. In fact, most of our matters, that's how they have been conducted. She would come at the very tail end. And as I said, that when those meetings happen to discuss where now the team says the matter, the investigation is complete, now we're ready to enroll. And that's how in most matters it would have happened, except for this one.
Then maybe the exception suggests that it should be an entrenched position in respect of which no ID has an option to deviate, and there's no exceptional matters, because all matters that come to IDAC must meet the criteria, so they cannot be exceptional and sensitive matters that only the ID should look at.
That is correct, Commissioner, and that's what motivated me to create the case intake criteria.
Okay. Part of the concern you have raised, or an explanation that you have given for not escalating things to the NDPP, you shrugged your shoulders, and we've had evidence as well that where matters have been escalated to the then NDPP, there was no good outcome out of it, and people seem to have ended up in worse positions than they were before they lodged the complaint. How do you suggest to fix for that kind of problem? Is it again a matter of, well, it's about the integrity of the people that you appoint, or it's a problem in this scheme that we have, where you have IDAC falling under the NPA, and ultimately the NDPP is the one that people must escalate things, but the NDPP has a working relationship with the ID because they all belong to the same organization. Is that the problem? And does, in your view, the appointment of the judge, IDAC judge, and whatever his terms of reference are, create a different playing field than what you had when it was just ID and NDPP?
Yeah, Commissioners, I think Unfortunately, the issue of the charge came much later, even though it was provided for in the legislation. I think it took time to be implemented. I would venture to say that had it been in place much earlier, some of these issues would have been raised with the office of the judge, and maybe there would have been interventions much earlier.
Do you say that because the terms of reference of the judge?
Yes.
Okay.
Remember,